Hello and welcome to HIPAA Privacy and Security Compliance Training for Employee Benefits, brought to you by Loomlight. On the agenda today, we will start with some of the background on HIPAA and its origins and go over the key definitions to understanding HIPAA. We will then cover both the privacy rule and security rule portions of HIPAA and how they apply to health plans. We will wrap up with how to handle breaches if and when those do occur. Beginning with the HIPAA background. We'll start with the legislative evolution of HIPAA. HIPAA stands for the Health Insurance Portability and Accountability Act. It was enacted in 1996 and is a fairly broad law that sought to establish standards for the protection of individually identifiable health information, or protected health information, also known as PHI, which we will define further on. But what was happening in the 90s is that all of these medical records were starting to be digitized, and legislators felt that this law was necessary to protect all of that personal data. In the early 2000s, then, we have several regulations issued that implemented the privacy and security requirements outlined in HIPAA in relation to protected health information. And when we think about HIPAA, these are the rules that we tend to think about, because these are what set the standards for entities subject to HIPAA. In 2009, we have the Health Information Technology for Clinical and Economic Health Act, or HITECH, which had the first substantive changes to that 1996 law, including increasing potential penalties for noncompliance and greater oversight and enforcement by the agencies of the HIPAA rules. It also changed how to identify when a breach occurred and what needed to happen if a breach did occur. It also made business associates directly liable for HIPAA compliance. We will circle back to what exactly a business associate is. Then finally, we have the Omnibus Final Rule in 2013, which finalized all these rules and actually incorporated all of HITECH's changes into the HIPAA law. And that was the last time that there was any lasting major legislative activity around HIPAA. So who do all of these HIPAA rules apply to? HIPAA applies to what it calls covered entities and business associates. Covered entities include who we generally think about when we think about HIPAA, healthcare providers like doctors and hospitals, but also insurance companies and clearinghouses, the technology firms that process claims, but also kind of roped into that covered entity definition were employer-sponsored health plans, including those sponsored by your employer. Business associates are third parties that perform certain functions that involve the use or disclosure of protected health information on behalf of a covered entity. So an example would be the third-party administrator for your plan, but there can also be less obvious examples of business associates, like an outside IT counsel who necessarily will have access to where PHI is stored, or a shredding company that may shred documents containing PHI. All of these are vendors of a covered entity. Importantly, before a covered entity can share any protected health information with a business associate, they must enter into a business associate agreement, which is a written document that ensures that the business associate will treat the protected health information in a secure and HIPAA compliant way. What information is protected by HIPAA? HIPAA applies to and protects what it calls protected health information, or PHI. PHI is any individually identifiable health information that is created, received, or maintained by a covered entity, like the health plan. It is important to realize that this definition is much broader than what you may consider medical information. It goes beyond a diagnosis or treatment information and will include any individually identifiable information, including something as simple as a name, address, or date of birth that has been created, maintained, or received by the health plan. Some examples of things that are not PHI would be payroll information or health information gathered from drug testing as part of the hiring process, or medical information related to an FMLA or workers' compensation claim. This is all information that generally would not come from the health plan, and so it is not PHI. Part of the trick in defining PHI is realizing that you may have two identical sets of data, two pieces of paper that each have the same date of birth or social security number on them, but only one piece of paper came from the health plan. Only that piece of paper will be considered PHI. The other piece of paper, while sensitive information, will not be considered PHI and will not be protected under HIPAA. Let's look a little more closely at employer health plans as covered entities. It can seem a bit like splitting hairs, but an important distinction to make is that it is the health plan that is a covered entity under HIPAA, not the employer themselves. But since health plans, as non-sentient beings, cannot comply with HIPAA all on their own, the employer, as plan sponsor, is responsible for the health plan's compliance with HIPAA. Additionally, not all plans that an employer offers will be subject to HIPAA. The HIPAA privacy and security rules apply to employee welfare benefit plans that provide medical care. On this slide is a table that categorizes some common benefits into those that are typically subject to HIPAA and those that are not. As you can see, though, from the number of asterisks there, it is not always a consistent categorization. For some benefits, we have to look more closely at either what the benefit offers or how it is structured to determine if the benefit will be subject to HIPAA. For example, an EAP or Employee Assistance Program will typically offer counseling sessions of some kind. As mental health care, that is medical care, and so an EAP is typically subject to HIPAA. However, it is possible that a particular EAP may only offer referrals to counseling, or perhaps only financial counseling. Those things are not medical care, so such an EAP would not be subject to HIPAA. Also keep in mind that just because a benefit is not subject to HIPAA does not mean that the information related to the benefit should be treated insensitively. It just means that that benefit is not subject to HIPAA and its information will not be PHI, but should be treated sensitively nonetheless.
Now we are going to look at what the HIPAA privacy rule requires. There are three core requirements under the privacy rule. First, the use and disclosure rules. These are the rules that dictate how and when a covered entity or business associate is permitted to handle PHI. The second requirement includes an individual's rights to their own PHI and the Notice of Privacy Practices that describes these rights, as well as how the covered entity uses individuals' PHI. And lastly, there are the administrative requirements that we will cover in a moment. So what does HIPAA say we can and can't do with PHI? There are certain uses and disclosures of PHI that are explicitly allowed by HIPAA in other situations that will require an individual's authorization prior to using or disclosing their PHI. The first category of permissible use is for treatment, payment, and healthcare operations. This category includes things like sharing PHI between healthcare providers to coordinate healthcare, eligibility determinations, claims processing, and coordination of benefits. For our purposes, this category primarily amounts to plan administration. HIPAA does permit the health plan, as a covered entity, to share PHI with the employer as plan sponsor in order for the employer to perform plan administration functions to keep the plan running, most often performed by HR or the company's benefits department. The second category of permissible use and disclosures of PHI is to the subject individual themselves or to their personal representative. An individual is always permitted to access or use their own PHI. A covered entity is also required to treat an individual's personal representative as if they are the subject individual. A personal representative is an individual who, under applicable law, is permitted to act on behalf of another individual in making decisions related to healthcare. One example would be that a parent will almost always be considered the personal representative of their minor child. However, it is important to realize that this personal representative designation does not apply to spouses, adult children, and most third parties. So in cases outside of a parent of a minor child, there will need to be some documentation of this person's designation as a personal representative prior to the use and disclosure of PHI. The third category of permissible use or disclosure will be for public policy related purposes. This category includes uses of PHI that legislators deem necessary for the broader scope of enforcing the law or protecting individuals, and includes the 12 specific purposes listed here. Outside of the three categories that we just discussed, any other use or disclosure of PHI will be permissible only if the individual's authorization is given. Authorization for use or disclosure of PHI can be written, and there are two key elements to pay attention to when relying on written authorization. One is validity. There are specific rules around what an authorization must contain, and there are certain elements that must be present in order for there to be a valid authorization, including a specifically stated purpose for the authorization, an expiration date of the authorization, and a statement that the individual has the right to revoke their authorization. The second key element is scope. Things to consider are whether this particular use or disclosure is within the boundaries established by the written authorization, whether it fits within the specific purpose that is stated, has the expiration date passed, is the person receiving the PHI identified in the authorization. All of these things must be present in order for the authorization to permit the use or disclosure of the PHI. There is a bit more flexibility when the individual has what HIPAA considers an opportunity to agree or object to the use or disclosure, or in other words, the use or disclosure is happening contemporaneously with the individual present either physically or on the phone. The best way to illustrate this is with an example. An employee may call the HR department to ask about one of their spouse's claims. Recall that the spouse is not a personal representative, so the spouse's PHI cannot be shared with the employee without authorization. Here, authorization can be given by handing the phone to the spouse, who can authorize the disclosure, and then hand the phone back to the employee who is now authorized to have access to the spouse's PHI for this purpose. Again, there are two key elements to pay attention to when relying on an opportunity to agree or object. First, such an authorization will only be good for that specific interaction. So in our example, if the employee were to call back an hour later, the spouse would need to reauthorize the disclosure of their PHI. Second is caller verification. HIPAA requires that there is a verification process in place so that you have a reasonable basis to believe that the caller is who they say they are. There isn't a specific way that this process must look, but best practice would be to verify some key pieces of information, like address or member ID, that the person would know if they are who they say they are. Now, even permissible uses and disclosures have limits, and that comes in the form of minimum necessary rule, which requires that only the minimum amount of PHI necessary to achieve the purpose should be used or disclosed. The goal of this rule is to limit any needless exposure of PHI, even for those individuals who are otherwise permitted to access it. Some common pitfalls around this rule include forwarding strings of emails. We've all been on those seemingly endless strings, and it's not hard to imagine that if PHI is part of that string, it would end up in the hands of someone that doesn't need it, thus violating the minimum necessary rule. Other common areas of caution include unnecessary access to PHI to employees who don't need access to PHI because they don't have plan administration functions, oversharing with business associates PHI that goes beyond what the business associate really needs, and misaddressed emails to individuals who don't need any PHI at all. Now for some impermissible uses and disclosures of PHI. To be clear, any use or disclosure of PHI that does not fit into any of the categories that were discussed and doesn't have authorization will be impermissible. Examples of impermissible use and disclosures include any kind of employment-related actions like hiring, firing, promoting, or demoting an individual. A manager can't look at your medical records, find out that you are getting treatment for substance abuse, and consequently demote or fire you. That is not permitted. PHI cannot be shared with employees who aren't involved in plan administration, meaning that those employees do not need access to PHI, so any access would therefore be impermissible. PHI cannot be shared with any third person who is not a personal representative, most common examples being spouses or adult children. And finally, PHI cannot be used in relation to any other benefits like FMLA, disability, or life insurance. For example, a medical certification may be needed for FMLA purposes. The employer cannot simply go to the health plan to get that information themselves. Next, we have individual rights. This piece of the HIPAA privacy rule is covered largely for educational purposes. Typically, people will go to their healthcare provider or carrier for these kinds of requests, but as a covered entity, the health plan must at least be able to respond to any requests they receive. First, individuals have a right to access the full set of their medical records, also referred to as a designated record set. Individuals have the right to request an accounting of times when their PHI was used or disclosed for purposes other than plan administration. Individuals have a right to request confidential communications, so they can request to have their PHI sent to them via alternative means like an email address or other physical address. The idea behind this right is that some people may be in an unsafe home environment and need their PHI to be routed in a confidential manner. The expectation here is that the plan will accommodate these requests. Individuals also have a right to request that the use or disclosure of their PHI is further restricted. The expectation here is that plans are not expected to agree to this if it is administratively impractical. Finally, individuals also have the right to complain about any practice that they see with respect to the plan and how it handles PHI, and regardless of whether the complaint has merit or not, the complaint must be investigated and responded to if made in good faith. These responsibilities can be delegated to the business associate, and that would be part of the business associate agreement in that case. And lastly, individuals have a right to receive a notice of privacy practices. The Notice of Privacy Practices is a document that you distribute to employees, and it informs them about their individual rights to PHI that we just covered. It also describes how the plan uses their PHI and the plan's obligations towards protecting their PHI. The notice must be distributed when individuals are initially enrolled, upon request, and if there is any revision to the content, then it must be distributed within 60 days. And if no revisions are made, a reminder regarding the availability of the notice must be provided every 3 years. Most often, employers will simply include the notice in their open enrollment materials that they'll distribute annually, and that will take care of this requirement. We have come to the final core requirement of the privacy rule, administrative requirements. The first of these administrative requirements is what is known as the mini security rule, in that it requires covered entities to reasonably safeguard PHI from any use or disclosure that violates HIPAA's privacy rule. These safeguards are broken into three categories. Physical safeguards, which include things like locking doors to rooms or file cabinets that house PHI, or shredding documents with PHI prior to their disposal. Technical safeguards, which refer to the technology that PHI touches and the policies and procedures for the protection and control access to PHI. And lastly, administrative safeguards, which will include administrative actions that are necessary to protect PHI and manage the conduct of the covered entity's workforce in relation to the protection of the PHI. For example, a policy of caller verification when sharing PHI or speaking quietly when PHI is discussed. Other administrative requirements under the privacy rule include appointing a privacy official and contact person. The privacy official will be the person that is ultimately responsible for the development and implementation of a covered entity's privacy policies and procedures. This person can delegate duties to other workforce members, but is the one ultimately responsible for the plan's compliance with the privacy rule. The contact person is the person designated to receive complaints or requests, like all of those individuals' requests that we discussed before. Workforce training. A covered entity must train their workforce on HIPAA compliance, like the training taking place right now. Prohibition on retaliation. The covered entity is prohibited from intimidating, threatening, coercing, discriminating against, or taking other retaliatory action against individuals for exercising their rights under HIPAA privacy or for participating in any process under the privacy rule, including filing a complaint. Prohibition on waiver of rights. Covered entities cannot require individuals to waive their rights under HIPAA as a condition of enrollment in or eligibility for the group health plan. Written policies and procedures. Covered entities must implement written policies and procedures that are designed to ensure compliance with the privacy rule. And lastly, there are business associate agreements, which we have covered, but as a reminder, a covered entity must enter into such an agreement with the business associate in order to compliantly disclose PHI to the business associate.
Now we will move on to the security rule under HIPAA. This rule applies to electronic PHI or ePHI, which you may have guessed is PHI that is in an electronic medium. The overarching goal of the security rule is to ensure that covered entities are putting in place appropriate protocols and security measures to safeguard that ePHI. To that end, the security rule has safeguards and requirements that must be managed, and they fall into these four categories, including administrative, physical, and technical safeguards meant to preserve the integrity of the ePHI, as well as organizational, written policies and procedures, and documentation requirements. Within these four safeguards and requirements, there are 22 different standards, each of which have between 0 to 4 implementation specifications. As you can see from the examples given, implementation specifications are split into two groups, those that are required and those that are addressable. Required implementation specifications are just that, they are required. Addressable items have more flexibility. The security rule was written to be flexible in its implementation in recognition of two facts. One, technology advances much more quickly than legislation can be updated. And two, covered entities come in all shapes and sizes, and so they are permitted to take into consideration their own size, mission, and purpose of holding ePHI when deciding what security measures are appropriate for addressable implementation specifications. For example, more stringent specifications are going to be appropriate for a hospital, versus those that are appropriate for a health plan. That said, the health plan still needs to do a few things to comply with the security rule. The very first step for a covered entity to comply with the security rule will always be conducting a risk analysis. This risk analysis is the bedrock for any covered entity's compliance with the HIPAA security rule. A risk analysis requires a thorough and accurate assessment of any potential risks and vulnerabilities to the confidentiality, integrity, and availability of ePHI that is held by the covered entity. This involves reviewing and identifying all of the ePHI that the covered entity holds and where that ePHI is used, shared, or stored, and identifying any risks or vulnerabilities to that ePHI. The covered entity can then develop a risk management plan that can best mitigate or reduce that risk to the ePHI. From the information gleaned through the risk analysis, the covered entity can then continue its security rule compliance by developing written security policies and procedures that describe the security controls that the risk analysis indicated would be necessary. Similarly to the privacy rule, the security rule also requires the appointment of a security official, who is the person that develops and implements those written security policies and procedures. For this purpose, it is good to realize that existing corporate security policies can be leveraged for this purpose. The security rule also requires training, but rather than HIPAA-specific training, this is security awareness training, which is much broader and can include things like phishing or scam identification. Next, these security controls must be periodically reviewed and refined. That risk analysis will only be relevant and compliant to the extent that the information in it is up to date. Work environments and operations change over time, and it is important to keep the security policies up to date with those changes to keep them relevant. Lastly, the security rule dictates how a covered entity must respond to security incidents or breaches, which is our next and final topic.
Moving on to breaches. What is a breach? A breach is defined as the acquisition, access, use, or disclosure of PHI in a manner not permitted under HIPAA that compromises the security or privacy of the PHI. Regulations impose a presumption of a reportable breach, which can be overcome only if it can be demonstrated there is a low probability of compromise based on a four-part risk assessment, which is part of the privacy officer's duties. Those four factors are the nature and extent of PHI. Consider whether the PHI is sensitive financial information, for example, credit card information, or sensitive clinical information, for example, medical diagnosis or history, the level of detail in the PHI, and whether the PHI could be used by an unauthorized recipient in a manner adverse to the individual. Unauthorized persons who received PHI. Does this individual also have an obligation to protect PHI? Whether PHI was actually acquired or viewed. For example, if someone found a lost laptop, could it be determined that the data was actually accessed? And finally, the extent to which the risk has been mitigated. For example, whether unauthorized recipient has given assurances that all copies of the PHI will be destroyed or will be returned without being further used or disclosed, and whether these assurances are verifiable and enforceable. Just as importantly, what is not a breach? There are a few circumstances that HIPAA accepts from the definition of breach, including the unintentional acquisition, access, or use by a workforce member if in good faith and within the scope of authority, and no further use or disclosure has been made. For example, if a workforce member is looking for a folder but accidentally and in good faith opens a folder with PHI but immediately closes the folder, there has been no breach. A breach does not include the inadvertent disclosure to a colleague who is also authorized to access PHI and no further use or disclosure is made. For example, a workforce member accidentally emails some PHI to another workforce member who doesn't need that PHI and they delete it. That would not be a breach either. And lastly, a disclosure where there is good faith belief that the unauthorized person was not reasonably able to retain the information. So an example here would be emailing PHI and then being able to successfully recall that email before it was opened would not be considered a breach. If there is a breach, then notifications must be made. Notifications to the affected individuals will always be necessary when there is a breach. The notification must be made within 60 days of when the breach is discovered or when it is reasonably determined that the breach should have been discovered. To be clear, a breach is discovered when it first becomes known or should have been known to any member of the covered entity's workforce, not just when the management or the privacy official becomes aware. If the breach affects fewer than 500 individuals, then along with the individual notification, the covered entity will also need to include that breach in their annual submission of logged breaches to HHS due within 60 days of the end of the calendar year. The breach affects 500 or more individuals, then in addition to the individual notifications, the covered entity cannot wait for their annual submission to report the breach to HHS. They will need to notify HHS of the breach within 60 days of the discovery of the breach. Additionally, the covered entity will need to notify media outlets within the state or jurisdiction of affected individuals. The notification of a breach must be sent to any individual whose information is reasonably believed to have been affected by the breach. The notification must use plain language, meaning it should be written at an appropriate reading level and not include extraneous material that could take away from the message. There are certain required elements for the content of the notification, including a description of the breach, date or dates of the breach, the types of information that were breached, a description of what the covered entity is doing to investigate or mitigate the breach, and any steps that affected individuals should take to protect themselves, as well as contact information for any affected individuals with further questions. This individual notification must be sent by first-class mail or can be sent by email if the individual has agreed to be notified electronically. If there is insufficient contact information for an affected individual to make the notification this way, then substitute notification must be made either by telephone or media, depending on how many individuals the covered entity has insufficient contact information for. If a business associate has a breach and accordingly notifies the covered entity of the breach, then the covered entity should still go through its own process using the four-factor assessment to determine if there is a breach. If the covered entity also finds that a breach has occurred, then the appropriate notifications will need to be made. Business associates will often be delegated the task of making these notifications, but the ultimate responsibility still lies with the covered entity should the business associate fail to provide the required notification. Even when a security incident is not considered a breach, there are still steps for a covered entity to take. First, mitigating any potential harm to the affected individuals due to the incident. This can include a request to destroy the impermissibly disclosed PHI and to refrain from further disclosure and can amount to making notifications to individuals. It is also appropriate and necessary to apply sanctions when there is a security incident that was caused by a workforce member violating the covered entity's written HIPAA policies and procedures. Keep in mind that whistleblowers who disclose PHI when reporting HIPAA violations to HHS cannot be sanctioned for such action. Finally, Any complaints, including those relating to any security incident, must be investigated and responded to. To summarize this HIPAA training, the major takeaways for you include ensuring permissibility of any use or disclosure of PHI. Does this use or disclosure fall into one of those permitted categories, or is there a valid authorization for the disclosure? If not, then check with your privacy official before acting. And if there is any use or disclosure of PHI that looks off to you, that should also be reported to your privacy official. Finally, keeping with the written policies and procedures up to date is a group effort. If something is out of date, bring it to your security official's attention for review. Congratulations, you have completed your HIPAA training. Thank you for your time and attention.